Right. I'm getting ready to call a motion for change of placement. All the parties are with us. I'll call the case here in just a second. I have Shay Carnes and Gloria Rodriguez in the waiting room. Do we need either of them in?
Troy Carnes is our caseworker. Gloria Rodriguez, I believe, is the intervener in the next case, Judge.
Oh, okay. All right. We'll leave her where she's at. All right, then. Amy, you ready? Okay. I will call for change of placement involving Miss Wildman is with us for the department. Miss Wiggins is with us for the child. Mr. Wilson's with us representing the mother who is with him. She's present. And Miss Graff is with us representing Dr. El Badrawi, who's the father, and he is also with us. That leaves only one. No one's in my waiting room except for the next case. So we are ready to proceed. Mr. Wilson, this is your motion, so you
Your
may.
Honor, if I may, I was wondering if we could bring up the issue of the department is not requesting a continuance. We had requested a stop to the proceedings. In addition to the email that was sent, there is another issue that I think needs to be brought before the court that I know at least Mr. Wilson is aware of. I don't know if the other parties are.
What issues would that be?
There was a confusion with the psychological evaluation that was ordered in the family plan of service at the last hearing. That has still not been completed. One provider did a psychosocial, however, both of those appointments were only scheduled for June 2nd. So there's no, even had this been done with the Dr. Schneider, the initial provider, there was no guarantee of that being completed or those witnesses being available for this hearing. So we would add that to our request to hear as much as possible today and then recess so the department can attempt to make those people available and their recommendations available to the court. I understand that Miss Graff had sent an email, that the father is wanting a decision made today. I don't believe that a decision can be made without that information regarding placement with the mother. I do think that the court could potentially make a decision today on whether or not Kareem is allowed to move to Wisconsin with his father, which would allow parties to at least begin planning for some sort of end of this month,
This is where the case takes a serious turn. The department is basically telling the judge, we don't have all the psychological evidence yet, but a life-changing relocation decision is already on the table. And that's the tension here. The father's clock is ticking because of the Wisconsin job, while the court is trying to avoid making a rushed decision involving a child. But here's the big question. If the evaluation delay was caused by confusion over the provider, should the parents be penalized for that? Or should the court move forward anyway because time is running out? Drop your thoughts in the comments, because this is exactly the kind of procedural chaos that can completely change the outcome of a CPS case.
Situation when he needs to leave the area.
When's the psychological expected back?
It has to be rescheduled. I don't know if Miss Abdal Hamid has done that. I don't know if Mr. Wilson knows that.
Judge, the problem is the order, the psychological was ordered. Our referral was to an LPC. I indicated to the department that, as far as I knew, an LPC could not do a psychological evaluation, and was continued to be told that that was where the referral was to. Initially, Dr. Schneider got involved because I sent her over there as private. We were just going to try to pay for it if we needed to get it done, even though the department was the one that was wanting it. And then they just insisted that that was going to be okay to go to the LPC. And I'll be honest, I just assumed, okay, maybe they can do that. She went to the LPC. Obviously, they can't do a psychological, and they could do a psychosocial. And so we hadn't rescheduled anything at that point. And so we've tried to be on top of it. I don't think she should have to come up with $2,000 or $3,000 to pay for one herself, but we weren't getting any referrals to anyone who could actually do a psychological. So I was trying to get her to somebody that I thought could do it. So I don't think it's quite fair to hold this up for something that we tried to forestall, but we're told we needed to do.
And if I can respond very briefly, Your Honor.
Well, let me ask some more questions first. Mr. Wilson, your motion says that the psychological wasn't added to the mother's plan of service until May 5th. Is that correct?
That is correct, Judge.
Okay. Ms. Wildman, if this psychological is so important, this case began in mid-March, why did the department wait so long to add a new service, wait till May 5th?
Your Honor, I can, if you're okay with me giving the information, those have to be approved through a supervisor, and so that does take a little bit of a process. So the only time we could have added that is when we did the family plan of service at the status hearing. That's the only way we could have had that court ordered, when we decided to have that approved. As far as the issue with the psychosocial, we were relayed by Ms. Lawson's office that she could do it. It was not until after the psychosocial was done that she relayed to Ms. Carnes that she cannot in fact do a psychological evaluation. So we do have other providers. We have Stonebridge that we could have done, but we were told by the provider she could do it. And so that we did not have a lot of time with the status hearing only having been a month, and then this hearing being requested so soon to, like I said, even if they had gone to Dr. Schneider, that appointment was not scheduled until Monday of this week. There's no guarantee that that would have been done, like the report would have been done, or Dr. Schneider would have been available today, even if they had gone to Dr. Schneider, because of how short of a turnaround there was between that appointment and this hearing.
Well, let me, Mr. Wilson, let me ask, your motion says that doctors has accepted a position in Wisconsin beginning in July. I thought I recalled from our last hearing, he said he had to leave the 1st of June. When's he leaving?
I think it's the end of June. End of June.
Okay, so we've got it until the end of June. Ms. Wildman.
Which is 3 weeks, Your Honor.
And Judge, I do want to point out that you did request that they go to mediation, and we did schedule a mediation for June 18th, and so we haven't even yet had that.
Okay, I don't see the point of start and stop. I don't like to do those anyway.
Notice how Judge Graham immediately shuts down the start and stop hearing idea. That's actually a pretty important courtroom moment. Judges generally prefer hearing all the evidence at once instead of splitting testimony across multiple days, especially in emotionally charged custody matters like this. And now the pressure ramps up even more. Mediation is scheduled, the father may leave Texas permanently, witnesses might not be available, and the court is basically saying June 20th is decision day. That deadline just raised the stakes for every single person in this courtroom.
So you definitely got your mediation scheduled for June 18th?
We have a full day scheduled for mediation in person with the PRPC on the 18th, Judge.
Okay. Let me pull up my calendar real quick.
And Judge, for the court, Mr. Reed has indicated he is free on June 20th if that's a date that the court is available.
Who's Mr. Reed?
The therapist that was the initial basis for our request.
Okay. I'm going to be out of town, but that doesn't mean I can't do it by Zoom on the June 20th. Brittany, are you with us?
I am.
Yeah, okay. We don't have anything else scheduled yet, do we?
No, this would be the only thing.
Okay.
I'm not around, Judge, but I bet we can find somebody.
Yeah, I mean, I can record it if I have to. As I said, I'll be out of town, but there's no reason I can't just take a break and have this hearing. How long do y'all anticipate? Let's say we get the psychological done, you get your mediation done. If we have this hearing on June 20th, how long do y'all anticipate it'll take?
If the mediation is not successful in any way, I think 2 hours may be fine. We might want to do 3 just out of an abundance of caution. If it is successful, we may be able to announce an agreement that day, in which case it would only be a couple minutes.
Okay. That's what I think I want to do then. I don't want to start and stop it. We'll just schedule it to come back on June 20th at 9 o'clock, and we'll have as long as we need. There won't be anything else scheduled, so we'll have as long as we need to take care of it that day. And I'll make a ruling that day. So I know the doctor's can't just stay here till June 30th and then have to start a job on July 1st. So we'll come back on June 20th. We'll come back whether or not the psychological is done and whether or not the witnesses that you want, Ms. Wildman, can appear.
I understand, Judge.
That goes for everybody. Any witnesses, if they can't appear that day, then you better think about doing a deposition or something before then. But I think that makes more sense. Then I can rule on that day and we can go forward on that. So, okay, is there
Your
any?
Honor,
Who's talking? Yes, Ms. Graff.
Ms. Graff, I do want the court to be aware that my client was told very sternly by his program coordinator for the resident program that he cannot miss any more days of work before the end of the month, at the end of his program. So that means that today will probably be the last time he can appear in court, and I will have to just coordinate with him to let him know what we're going to say, and then what has happened. And I apologize to the court for that, but he's got the last 3 weeks of his program, and he has no control over what they're requiring of him.
Okay, well, you just kind of do what you have to do. We'll be back on June 20th at 9 o'clock, and we'll take all the testimony that you can offer the court, and then I'll make a ruling that day. So, is there anything going on right now with Kareem that we need to talk about today?
Ms. Carnes, are there any updates that the court needs?
No, ma'am.
Okay. All right, then. I'll see y'all back on the 20th at 9 o'clock.
Your Honor.
Yes.
My client does want the court to be aware that his son has been to 7 sessions of play therapy. I don't know how long that he hasn't been told how long he needs to continue in the play therapy. But as I have indicated to him, if he ends up moving with the child to Wisconsin, then obviously the play therapy is going to end as far as Texas goes at the end of the month.
Okay. Well, I mean, I guess I would leave that. Who's the therapist?
Delois Hinders.
I would leave it to her to say whether or not it needs to continue or not. So.
And Judge, I think he's making some progress, but I think it would be, as long as he's here, I think he would need to proceed.
Yeah, I don't see I don't see it can hurt for him to stay in play therapy till we come back here in 2 weeks. So, okay. Anything else we need to
thank you,
Doctor? You had your hand up. You're muted. You're muted.
Okay. Your Honor, I would like to request that, like any of our court hearings, not to be.
And wow, this final moment changes the emotional tone completely. After all the legal arguments, scheduling conflicts, and procedural debate, the father suddenly reveals another concern: these hearings being broadcast publicly. You can hear the anxiety there. CPS cases already involve deeply personal family issues, but when someone says they're a public figure and worried about YouTube exposure, it adds a whole new layer of pressure and vulnerability. What do you think? Should sensitive family court hearings involving children be publicly available online, or should privacy come first in cases like this?
Broadcasted on YouTube, because like I'm a public figure here and all the community